Welcome to the Sanctions Age, the podcast that explores how sanctions are changing the world. My name is Isfandir Batmanghelidj. There's a powerful office in the U.S. Department of Treasury called the Office of Foreign Assets Control, or OFAC. Arguably, the officials at OFAC are the most powerful government functionaries in the world. They're the ones who sanction companies, organizations, or individuals by adding these entities to a list called the Specially Designated Nationals List, or SDN List. Today, there are over 17,000 designated entities. The list includes Iranian government institutions, Afghan jihadists, Russian state enterprises, Venezuelan officials, and Mexican drug lords, anyone that the U.S. deems a threat to national security. My guest today is an attorney who frequently represents clients before the Office of Foreign Assets Control. Erich Ferrari is founder and principal attorney of Ferrari and Associates, a Washington, D.C.-based law firm. Erich represents U.S. and foreign corporations, financial institutions, exporters, insurers, as well as private individuals in matters related to trade compliance, regulatory licensing, and federal investigations and prosecutions. Erich, welcome to the show.
Thanks for having me on, Yar.
So I've asked this question, I think, of you before in one of our past meetings, but I thought it would be good to kind of ask it for the sake of our listeners, which was a little bit about how you got into the sanctions practice. Because, if you go back a decade ago, sanctions were a relatively niche practice, something that, a handful of specialists were working on, mainly related to issues around Iran or Cuba. And today we're in a very different situation. Sanctions are front page news, week in, week out. So I'm curious to know, what drew you to the field of sanctions law and, particularly when it was still a niche area, and what's driven its growth and how has basically your practice changed in the last sort of decade?
Sure. So my entryway into sanctions law really began right around 9/11. I was coming out of law school. I was a senior in college and was going into law school, rather, the following year after 9/11. And I was very interested in national security law, foreign affairs, those sorts of issues. I grew up in a household of Iranians because my mom is Iranian. And so here I was constantly surrounded my whole life by talks of Middle East politics and what's going on with Iran and the U.S.-Iran relationship. And so I was always drawn to that and very interested in that. And then, going into law school right after 9/11, I became very interested in national security law and how U.S. law and international law was impacting the U.S.'s war on terror. And so when I got to law school and I started researching these issues, I realized pretty quickly that the primary issues at that time were the treatment of Guantanamo Bay detainees. And so that put you either on the side of representing those detainees or prosecuting those detainees through the JAG Court. Well, I wasn't really interested in defending the detainees. I was a little bit more interested on the prosecution side and had a lot of thoughts about joining the military and going into the JAG Corps. My mom was an ardent pacifist, is still an ardent pacifist, talked me out of it. And so I was kind of at a loss as to what I was going to do in the national security law realm. And I was working as a research fellow at a place called the Center for Terrorism Law, which was an academic organization at our law school under grant from the Air Force Research Laboratory. And it was looking at nascent legal issues in the war on terror. And during that time, I came across some cases where this little agency in the U.S. Department of Treasury had frozen the assets of some Muslim charities in the United States, and there was some litigation going on around that, in particular the Holy Land Foundation case. I was in law school in Texas, and so that was a case out of the Northern District of Texas, if I recall correctly. And I kind of said, what is this agency? This Office of Foreign Assets Control? Where do they get this power from? And that's kind of what drew me into that area, this kind of intersection between national security law, administrative law, and the use of it to carry out kind of foreign policy objectives, but against U.S. persons. So that's where I started. What's driven my continued interest is just that it's an ever-changing area of law. It's really dependent upon geopolitical factors, what's going on in the world, because there's really two sides to sanctions. There's a technical side, and then there's a policy side. And there's enough ambiguity in the law and enough area of discretion and deference for the agencies who are administering these sanctions for them to view things differently or interpret things differently depending on how they want to use the tool to respond to a particular geopolitical circumstance. And that's probably, what's kept me involved and interested in sanctions for such a long time. I'm now going into, it's going to be my 19th year of practice, and researching these issues for almost, close to 25 years at this point. So I would say, what are the biggest changes over this time? There's a lot more sanctions that are addressing a lot more types of activities and statuses. We've seen it go from our practice from mostly Iran-related to a lot of Russia-related, obviously, a lot of corruption-related sanctions. And so now more and more cyber-related sanctions are becoming a part of our practice and having to deal with those programs and those issues. So just the growth of our practice and our interest in this area has kind of coincided with the growth in the use of sanctions. And I assume that growth in sanctions, I'm not a policy guy, I'm a lawyer, but I assume that growth in sanction is because the threats today are more varied and more pervasive than they've ever been.
So I think we'll get into that in a little bit later in the conversation, but one thing we can say is your mom seemingly had very good instincts because, she kept you open to this idea of pursuing a different kind of law, and you've ended up choosing maybe the fastest growing area of law in the US. But I want to talk a little bit about actually the mechanics behind the fact that the SDN list has grown. So as you mentioned, it's become basically Washington's most far-reaching economic policy instrument, and you have individuals and companies on the SDN list, but also vessels, aircraft, even crypto wallets can be sanctioned. And the implication of getting added to the SDN list is obviously that your assets get frozen and you get effectively cut off from the US financial system. But beyond that, it's not really transparent for most people how exactly people get added to this list, or companies or other kinds of entities. Can you walk through that process a little bit? How do you get on OFAC's radar, and then how does your name get on that list, and what are the implications from then on out?
Sure. It can come from so many sources. You can't say it comes from one source. It could be from domestic law enforcement sourcing. It could be from intelligence, both our domestic and foreign intelligence agencies, or foreign intelligence partners. Information can come from those areas. Information is oftentimes published or provided directly to OFAC or the State Department from non-governmental organizations who are campaigning against corruption or human rights abuses. It can come from embassy reporting. Quite a bit of it comes from embassy reporting, people going into the embassy and saying, we know so-and-so bribed this person to get this law passed, or whatever it might be. It can come from financial institutions and the information that they're seeing and sharing. So it comes from all these sources. And I think OFAC gets a lot of the blame for U.S. sanctions failings or problems. And I think that's really unfair because OFAC is largely the administrator, right? Mm-hmm. All of these agencies and sources are feeding information into it, and OFAC's job is essentially to aggregate that information and develop packages and to make sure that they have identified targets who meet the criteria for designation pursuant to some particular designation criteria contained in a statute or an executive order for either engaging in conduct which is sanctionable or meeting a status which is sanctionable. Now, OFAC doesn't make that call alone. A lot of times that call is made at higher levels, NSC, White House, the State Department. And so, for example, OFAC the U.S. government might want to take action against Iran's UAV production. And so they might say, identify for us targets and place them on the list for parties who are involved in Iranian UAV UAV production and distribution. And OFAC will have information ready, and they'll prepare those packages and roll out a sanctions action which targets, parties who are involved in that sort of activity under, whichever relevant executive authority, executive order or legal authority that they can. So that's kind of how it works. There's not one way to bake the pie, so to speak. It can be done a lot of different ways. And oftentimes, once a designation is imposed, OFAC is primarily looking at mapping out the network connected to a particular designee. So you get, let's say, just a large-scale, money launderer in a particular South American country. They get designated based on information that's come from, the DEA and maybe, let's just say, the Colombian National Police or whomever. And then OFAC's job thereafter might be to identify what companies are owned or controlled by those persons or acting as proxies for that particular target, or who are the frontmen for the particular target who are allowing it to continue to engage in sanctionable conduct after the designation occurs. And so OFAC is both involved in developing these targeting packages, as well as continuing investigations to map out networks that are providing support and assistance and acting on behalf of sanctions targets.
And it sounds like, OFAC is constantly being fed this information about entities that may be engaged in sanctionable conduct. It sounds like they are preparing these packages, which seem to be a combination of information about the entity, the networks they're involved in, the activities they're undertaking that may be sanctionable. But then it also seems like there would need to be some kind of justification as well for why, from a national security perspective, this individual or company is being added to the list. That decision seems to be more of a political decision. And I think very rightfully, you've identified that OFAC is mainly a kind of administrative body within the US government. Where is that political decision or that final call coming from, where basically OFAC then is given instructions to add a certain entity onto the list?
Yeah, a lot of times it's State Department and the NSC. So a lot of those decisions are coming from the top, from either, again, that department or from the White House through the NSC. So really they're involved on determining what the policy is and how the policy is furthered by the use of sanctions. And I would also say, you mentioned national security, but I think it's important to also understand sanctions are imposed not just for national security objectives, but more and more so to meet foreign policy objectives and to promote U.S. economic interests. So really, when you think about the policy side of the use of sanctions, we always kind of use for shorthand national security interests, but really it's national security, foreign policy, and economic interests, which all kind of drive the policy.
Well, let's unpack that a little bit more. I mean, we have seen this connection between OFAC designations and sort of U.S. foreign policy imperatives develop in the last 2 decades. I mean, you see moves like sanctioning Russian oligarchs or Iranian officials or Chinese companies. And on one hand, these are moves that are about potentially punishing these actors for activities they've undertaken that the U.S. thinks are bad in some way. It's also about sending a kind of signal to other actors that they should maybe change their behavior, otherwise they will also be punished. So it's a kind of deterrence function. But you're describing that they also have this kind of more political purpose, which is about signaling U.S. disapproval or trying to show that the U.S. is taking action in certain areas. And what's striking about that is that I think certainly coming out of your experience in the war on terror, sanctions emerged out of this sort of more law enforcement mentality. Like they were meant to be a tool that kind of extended U.S. jurisdiction. But this increasingly political use of sanctions doesn't necessarily sit alongside a kind of pure law enforcement view of what this tool is and how it's supposed to work. So, I mean, how do you think policymakers are weighing between the symbolic purpose of these measures and their actual material effects? And how has that kind of changed the way that you, as an attorney working in this field, have to navigate between kind of what the sanctions purpose is and what their actual effect is for entities that you might be representing?
Yeah, I think, look, there's not a consistent narrative as to whether sanctions should be used to compel a change in behavior, to promote a foreign policy interest, to punish a party, to deter other parties. It's really dependent on the circumstance, the administration, and the individuals, the stakeholders who are involved in how they want to use the tool. I mean, the tool is so, there's so much deference in the use of the tool that really on the policy side, they can use it for whatever purposes they really deem fit and justify it. And so I can't say that, you know, okay, well, this is what they're thinking every time they use the tool. So, you know, one day they might be targeting a particular network because there is a law enforcement imperative that they want to advance. Another time it could be that they're sanctioning a, you know, parliamentarian in an African country because it's a foreign policy issue, or they're sanctioning a bunch of Russian business elites because they want to send a message to not do business with Russia, and these people have varied in international business interests. So there's just no consistency. It's really kind of what they need the tool for on that day, that particular, you know, administration and the people involved in making those decisions. It's really made things challenging as an OFAC lawyer, because again, I'm not a policy guy, right? So when someone comes to me with their case, if they would have came to me in 2010, I would have said, listen, this is about changing their behavior. And so you have been sanctioned for doing X. We need to change X. You started to see that change right around the mid-2010s a little bit. And it became more about, well, this is punishment, so you haven't been on the list long enough. Your client hasn't been on the list long enough. And if we took them off now, it would show people that sanctions are short-lived. And that's something that the U.S. government has actually said in one of our cases. It's a public case. It's Canton-Tima v. Gacki, but which involves a former DRC election official. But OFAC received foreign policy guidance in that case to say, well, if we were to remove this individual now, it would send a message broadly that sanctions are short-lived and you can resume sanctionable conduct after a few years of being on the list. So there was kind of that evolution away from, hey, just change the thing they sanctioned you for and you can come off the list, to, well, have you been on the list long enough, to, all right, what's the message that this is going to send? And then in Trump 1, what we started seeing in the OFAC press releases, particularly with respect to Venezuela, was it wasn't just about changing the behavior anymore. It was about engaging in proactive activity which would further or promote U.S. interests. So we have this evolution from change, we're going to impose sanctions so you change what you're doing, to we're going to impose sanctions so that you can start doing positive things for the U.S., as opposed to stop you from doing negative things from the U.S. And the way they've justified this in their decision making is, well, if you're not doing things positive for the U.S., how do we know that your behavior has really changed? Right? The behavioral change is not just you abating the conduct for which you are sanctioned for, it's you abating that conduct and doing things in furtherance of U.S. national security, foreign policy, and economic interests. And so it's really given rise to new approaches in the sanctions field, where you need to be thinking creatively, not just about how to change the circumstances OFAC identified, but how this particular target, if you want to remove them from the list, how doing so would be beneficial for the United States. And so you're effectively not only, you know, addressing the issue, but now having to come up with creative solutions to sell the issue as well, and to make sure that the stakeholders involved in this process know, hey, okay, this person was sanctioned for XYZ activity, but this is what they're doing now, and this is why it's beneficial for the U.S. and why, to use that concept of punishment and reward, they should be almost rewarded by being delisted for these good activities that they're doing or proposing to do.
It almost reminds me of like a criminal presenting themselves to a parole board and trying to show that they're reformed and that they've been doing good things while in prison, that then they'd be able to continue if they're allowed to have their term shortened. So, I mean, that's a profound shift. But I guess I do want to go back to kind of this situation you find yourself in, which is that people call you and say, I've just been sanctioned, and they may think it's unwarranted and they want to get themselves off the list. And I'm curious to understand a little bit about what is the sort of set of facts that you try and determine through the information that's provided to you by your client. Because as you've described, OFAC is making its designation on the basis of a package of information that is, sourced from a wide range of different sources. And presumably when you sort of take on an assignment from a client that maybe thinks they've been sanctioned incorrectly or don't deserve to have been sanctioned or added to the SDN list, they are going to try and present you a set of facts that sort of justify that belief. What's that process look like where you're trying to understand the nature of your client's activities and also trying to determine how that lines up with the information that the U.S. government may have available to it?
Sure. So the first conversation I have with anyone who's on the list, who's seeking delisting, is to explain to them that the process is simple, but it is not easy. And even if you have good facts, it doesn't necessarily mean that you'll be removed. Second, I get into the legal standards. And I think this is really important for anyone who's going to go through the process to understand. OFAC does not need to prove that you engaged in the activity or meet the status for which you were sanctioned. This is not beyond a reasonable doubt that you would have in the criminal system. This is not probable cause, meaning that you probably engaged in the conduct or meet the status. It's not preponderance of the evidence. The legal standard in this process is whether OFAC has a reasonable cause to believe. That means they have some information in their possession that they have deemed credible to suggest that you have engaged in some conduct or you meet a particular status for which sanctions can be imposed. So a party who approaches us and says, I didn't do it, OFAC is totally wrong, I say, it doesn't matter if you did it or not. It's whether or not they have evidence in their possession that gives them a reason to believe you did it. And guess what? The majority of evidence is, in most cases, is typically classified and withheld from both the lawyers representing the sanctioned party as well as the sanctioned party itself. So you would effectively have to go in and say, whatever evidence you have that I can't see is not credible and doesn't give you a reason to believe that I meet this sanctionable status or having engaged in sanctionable conduct. Moreover, I think this is important, and this is what the courts have said is okay, because OFAC has taken its position in litigations we've had. What the courts have said OFAC can do is if you present information that rebuts what OFAC has said, but doesn't necessarily rebut or impugn the credibility of the evidence they have in their possession, which you can't see, that's good enough for OFAC to maintain the designation. So even if you can come in and say, I have strong, credible evidence that I didn't do this, OFAC, if they have their own evidence, which they've deemed to be credible, can say, it doesn't matter that you have that evidence. We can keep you on the list. Okay. So I explain all of this to the client. I get into the weeds of what the technicalities are, because the point is, this is, again, a simple process, but it's a hard process, right? And so we start there. And I tell clients, if you're going to fight them on the facts, you're probably going to lose. You're going to spend a lot of time, if you hire a lawyer, probably a lot of money, just to end up in the same spot you are today. The way to actually deal with this is not to challenge OFAC on what they've done, but to navigate yourself through the process, which is to say, okay, OFAC, you have said X about me. Since that time that you've said X about me, these are the circumstances that have changed. and why what you said I did, which I'm not admitting to necessarily, why it's not true today, and why it won't be true in the future. So effectively what we do is say, we sit with the client and we say, okay, this is what OFAC's saying you're doing. Where could they have gotten this idea? Maybe we identify a few circumstances that could have led to OFAC having that idea about them. We change those circumstances, and then we identify what can the client do to propose remedial measures or undertake remedial measures so that OFAC is not only comfortable that the circumstances have changed, but that they won't resume in the future. We walk them through that. And then even once we've done all that, that's the technical side of the equation, we have to look at who they are, right? As a person, what their profile is within a particular industry or region or country. We have to look at that particular program. Are we dealing with a Lebanon program or a global Magnitsky program, or are we dealing with Iran or counterterrorism or counter-narcotics? Different programs at different times are more hot than others, and it might be more difficult to remove someone under the counter-narcotics program under this Trump administration than it was, a few years ago under the Biden administration. And these are just facts. Administrations have different policies and priorities. And then you also look at how long have you been on the list. If you got on the list last month for running guns to the cartel, well, guess what? You're probably not going to come off the list. It would take a lot for you to come off the list. Now, if you were sanctioned for engaging in corruption in 2014 in, I don't know, Lebanon or somewhere, okay, your chances are a little bit better, right? The program's not as hot. A lot of time has passed, et cetera. And if OFAC doesn't have more recent derogatory information to keep you on the list, then maybe they'll be a little bit more open to delisting. So you look at all of these factors, and you just really have to be realistic about the process. There's a lot of people who run around and say, I know this guy, and I was this in the government before, and blah, 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 blah. Listen, maybe it's true. Maybe it's not. Here's what I know. I've been doing this for almost 20 years, taking people off the list, taking a lot of people off the list. It really comes down to the facts and the timing and what is the benefit to the U.S. government in delisting the particular party.
So I think it's really interesting that basically you're describing this quite technical legal process of kind of accounting for the facts that maybe OFAC took into consideration when they made the designation, and then showing why a new pattern of facts has emerged and why maybe there were steps to remediate some of the issues that that entity might have been involved with. But it does seem like a lot of the lobbying around getting delisted is increasingly happening in public, at least for high-profile designations, where you can see, if you're following these issues, that there might be a kind of public relations campaign, or there might be sort of lobbying from different stakeholders in and around the US government or on Capitol Hill. And then there's also the diplomatic component. You mentioned that different sanctions programs are hot at different times, and that there are different stakeholders who have their interests involved, including stakeholders in foreign governments. How have you seen that kind of evolution in the non-legal course of action that a designated entity might take to try and make the case to OFAC? So, you're saying that it can take a long time to come off the list, but there is a sort of process that can be followed. If someone's very eager, is it the case that they can try and sort of lobby through different channels to get a political decision to be made to get them off the list faster?
So, yes, but there's a lot of caveats on that. First, I think it's important to understand that U.S. persons cannot provide media advocacy or public relations work on behalf of a sanctioned person. They also can't provide any lobbying. And there's this big misconception that you lobby to get off the sanctions list. Lobbying is prohibited. It's outside the scope of the general license for legal services. I know from past experiences, having seen the determinations from OFAC, that those license applications to engage in those activities have been denied. So there's this myth that's been perpetuated that you got to lobby and talk to congressmen and do a public relations campaign. And all our clients ask us the same question. I'm like, that's not legal. As a matter of fact, not only is it not legal, people have gone to jail for that activity. If you look back, there was a case from the 2010s out of the district of, I think, Northern District of Illinois, Chicago area, in which some businessmen went to jail for a number of years for lobbying on behalf of the removal of sanctions against Mugabe. There was an OFAC enforcement action from a few years ago against the group in New York for engaging in permissible services, lobbying-related services as well. So I hear this stuff all the time. I don't know where it comes from. It may come from the following, which is, notwithstanding that you can't lobby, you can't engage in public relations, et cetera, on behalf of sanctioned persons, there is the ability to communicate with stakeholders in the interagency process who are involved in the implementation, administration, and enforcement of sanctions. So there have been people who have gone to State Department, NSC, DOJ, et cetera, to say, hey, there's a sanctioned person on the list. We have a delisting petition before OFAC. We know that your agency will be involved as part of the interagency review process to determine what the determination should be on that particular delisting petition. And here's what you should understand about the particular circumstances of the designation or the delisting petition, or what this person can do for U.S. national security, foreign policy, and economic interests. Now, there's another component of this too, which I think is actually more effective than what I just mentioned, which is if you have an ally of the United States who's going to communicate with their counterparts, meaning an ally being a foreign government that's going to communicate with their counterparts at the State Department and say, hey, this company is strategically important for our country, or we're going to undertake the following activities to ensure that this company doesn't engage in sanctionable conduct in the future. That actually can be really effective. Kind of this country to country advocacy. And we've seen that be more effective than kind of the outreach to the interagency. Although I'm not saying that the outreach to the interagency doesn't work. I don't have a terrible amount of successful experience with that. Let me put it that way. But I have heard a lot of people doing that and proposing that as a strategy. One of the things we've seen recently is that, particularly under this administration, is that there's this belief that it's all about getting to the White House, right? And so, there's been a number of people who have chided us for going through kind of more the technical route and going through the delisting process and saying, that doesn't matter. You just need to get to the White House and talk to the big guy and you'll get removed. I don't think that's true, to be honest with you. I know a lot of people are saying that. I do think this administration is a little bit more open to the idea of, hey, if someone is going to do something good for U.S. national security, foreign policy, and economic interests, maybe we should hear them out. So I think maybe there's more of a attitude or temperature under this administration to be open to the idea of delisting when it makes sense for the U.S. But this idea that you're going to hire a lobbyist that's going to go to the White House and get you off the list because you're a good guy, I haven't seen that. Or because their client's a good guy, I haven't seen that play out realistically. And it just doesn't sound consistent with what I've seen in my years of practice.
I guess if any SDNs are listening to this podcast, they'll know now not to throw their money away on lobbyists promising them some kind of secret meeting at Mar-a-Lago to get off the list. But we've mainly been talking about instances in which the entity that has been listed has probably undertaken in some kind of sanctionable conduct. But, as you've described, OFAC is gathering sources from a lot of different channels of intel. And ultimately, it's also an organization comprised of human beings, and human beings can make mistakes. And there has been some interesting reporting on instances in which designations are completely made in error. The Washington Post ran an excellent report, I think last year. I believe it was by Jeff Stein, the reporter. And he was looking at a case in which there was a mining company in Guatemala that was listed. There were two companies listed. One was correctly listed because it had engaged in sanctionable behavior or conduct, and the other company was completely a mistake. The OFAC believed that there was some kind of corporate relationship between the two entities when there was not. And eventually, the listing was reversed, the mistaken one. But it took a while, and in the interim, the company had basically shut down operations. And for a small community in Guatemala that was very dependent on this mine for their livelihoods, it was quite devastating. How often is OFAC making mistakes? I mean, of course, there's 17,000 entities on the list now. There's this tremendous pressure to keep adding these lists, preparing these packages. Are mistakes becoming a bigger issue within kind of the world of the SDN list?
I don't know. They've always been there, but they're the exception, not the rule, has been my experience. So some OFAC sometimes rely on mistaken information or outdated information. Yes, it happens. I can't say that it happens more frequently now than it's ever happened. I think a lot of this is driven by using sanctions to respond to emerging threats or, geopolitical developments. And, the White House puts out, a mandate or a directive to OFAC that we need to put we need to address a certain issue through sanctions, and the sanctions investigators are pulling from open source, and sometimes things get confused or mistaken or conflated. And, what's that saying from the tech industry? Move fast and break things, or something like that.
Exactly. Yeah. It's a scale problem, basically. They're trying to scale too fast.
Yeah. Trying to move too quickly, limited resources, limited time, and mistakes happen. But I can't sit here today and say, as having represented hundreds of people, on the SDN list, or people and entities on the SDN list, and say, 40% of the time OFAC's wrong, completely wrong on the facts. Mistakes happen, but again, I would, given the burden that's put upon the agency and the resources available to them, I think they actually do a pretty good job. I don't want to say getting it right, but rather having sufficient information to take the action that they've taken.
Do you know off the top of your head how many people are at OFAC at the moment? I think it's in the couple hundred, maybe, right?
That's my understanding, but I don't know. It is a very small agency. Yeah, it's a very small agency.
I mean, this issue of mistakes, obviously, it is the exception and not the majority of cases. OFAC is obviously, using reliable information and making a very reasonable determination. I guess the question then becomes, if an entity is sanctioned by mistake and the basis of their designation might be information that's classified or, as you described, not available to them, I mean, how is that a process that they can go through? Because as you sort of laid out, an entity that was engaging in sanctionable conduct, they can show that they've changed their behavior and, are remediating and go through that process as part of the petition to get delisted. It almost seems to me that it would be even harder in some ways to convince OFAC that they have made a mistake. I mean, is this something that you've encountered where is OFAC receptive to the possibility that maybe a mistake has been made if information is presented to them? And how can an entity kind of prove that if they're not able to see the package that was the basis of their designation?
Yeah, it becomes incredibly difficult. I haven't seen a scenario where OFAC has said that, there's a mistake in the classified reporting. I mean, the classified reporting is typically coming from CIA, State Department, DEA, HSI, other agencies. And so those are viewed as inherently credible. And you can't attack the credibility of it because you can't see it, right? So you don't even know what it says. And that's why I always tell clients, don't bother. They've said you engage in X. It's probably not true. If you're saying it's not true, fine, I believe you. But how are we going to address the concern rather than attack the allegation, right? And so I say, if you really want to get off the list, we need to just accept at face value that they have this concern. You don't have to admit to the allegation, but we need to present circumstances to say, okay, you guys have said I did X, well, I'm doing Y now, and I'll do Z in the future. And thus, there's no basis to keep me on the list, given this change in circumstances. And, just keep it moving at that point, because, again, I've done both. I've been doing it a long time. And so I fought OFAC so many times in court. I'm the most prolific, attorney of suing OFAC in the history of U.S. economic sanctions. But you learn through that process that they might make procedural mistakes, but if you're going to fight them on the substance of what they say, the courts are going to defer to them. They have broad discretion, and you can't even see what you're fighting, right? So you're better off, again, going to the point we talked about earlier, just identifying how you can deal with their concern as opposed to how you can disprove their allegations.
I mean, it seems to me that it's one of the toughest kind of gigs in a sense, a defense attorney that you could possibly have, because you don't even have this like discovery where you get to see what the other side has come up with. Erich, you've been doing this now for almost 20 years. When you think about how the system works, I mean, we've talked about some of the ways it does work. Obviously, you can get delisted. There is a process. We've also talked about some of the challenges and things that make it difficult, especially as OFAC continues to scale and has limited resources. Looking back at your experience, I mean, what would you sort of say are the ways in which OFAC or the US government more generally could improve the way that the specially designated nationals list is created, maintained, and sort of monitored to ensure that, this is a fair and maybe slightly more transparent system moving forward?
Yeah, so one thing I've advocated for a long time is modeled based on what the Obama administration did under the old Burma program. So when there was this idea of sanctions relaxation under the old Burma program, there was kind of a roadshow that was done in Southeast Asia in which Burmese designees heard from U.S. State Department officials, I think some Treasury folks as well, as to what the expectations were for them to be delisted, and certain criteria that needed to be met and actions that they would need to take. And a lot of it dealt with, adopting corporate social responsibility programs for their companies, divesting from certain projects or certain lines of industry, divesting from certain relationships. And I really think this process could be a huge win for the United States if they were just a little bit more transparent on the front end about what they wanted from the particular person or the particular entity. And the pushback we've heard in response to that has been, that changes, and what if they're engaged in other stuff we don't know about at the time, and our delisting criteria doesn't adequately account for that, and we learn about it later, so on and so forth. But really, here's what I tell folks at Treasury and State all the time is the first year or two that someone's on the sanctions list, they're under such intense pressure that they will effectively engage in whatever behavioral changes the U.S. government wants to see, just to alleviate the pressure. But after a few years, they start to learn to live under sanctions, and they're less inclined to take steps that the U.S. government might want to see them take. And in particular, when I go and say, I think you should do X, because we think that's what OFAC would want to see, clients come back and they say, did OFAC tell you that? Well, no, they didn't. Well, how do you know that then? Well, we have people who used to work at OFAC here. We've been doing this a long time. We're seeing trends across our cases. And they'll say, if OFAC asks me to do that, I'll consider it, right? And so it's just a little bit more transparency with the targets and with their counsels as to what actually needs to be done, I think would go a long way, and it would create huge wins for the U.S. But, there's also these other concerns about, well, if we tell them this, it might reveal our sourcing for certain information, or, again, that point I brought up earlier, what if we find out other stuff later? I would say this, OFAC is making changes to the delisting process. They've now stood up a team with an assistant director that's focused on the delisting process and adjudication of these petitions. There was also a notice regarding for public comment regarding a new reconsideration portal where parties will be able to submit petitions and information relevant to their delisting petitions. It could make it a little bit more streamlined and efficient. So I know that OFAC is definitely working on ways to improve the system. It sounds like they're doing a lot of great things. But I always go back to this transparency and letting these people know what they have to do to actually come off the list.
You've said a few times in this conversation that you're not a policy guy, you're a lawyer, but it's interesting because that specific recommendation is something I've heard a lot from people who are looking at these issues from a policy perspective and also have a consideration for the efficacy of sanctions. So if you are trying to use this tool to change behavior, it might be helpful to tell the targets what they need to do in terms of change behavior to not come under the pressure of the sanctions. Erich, we've reached the end of our time, which means I have to ask you the question that I ask every guest on the show, which is, when did you realize that sanctions are changing the world?
I realized that sanctions were changing the world. Gosh, great question. There's been a few different times. I would say right around 2010, when the CSADA came out, the Comprehensive Iran Sanctions Accountability and Divestment Act. And we saw a large number of Iranians and businessmen really kind of start to take interest in what are sanctions and how will this impact us. And, there was all this buzz about sanctions. So I would say that was kind of the first time. Then I would say the second time was with the global Magnitsky sanctions, when Executive Order 13818 was issued, and I saw, okay, well, it's traditionally been about national security and law enforcement, and this is really kind of going beyond that. And there have been programs dealing with kind of more foreign policy issues, but this was a big one, attacking corruption in foreign countries. And I really saw parties start to be concerned about, okay, what actions can we take in our particular jurisdictions to make sure that we're addressing corruption at a level that, or, consistent with expectations of the U.S. to ensure we don't end up on a sanctions list someday. And then, of course, with Russia, it was so huge. Everything, in my personal world changed because, overnight, we're a lot busier, and we've been a lot busier since the invasion, but we also saw how far-reaching the sanctions are. When you target a country that is that large and that integrated into the global economy and all of the little issues that come up because of their integration into the global economy, you realize how far-reaching the sanctions were. And look, I'm someone who's always out there seeking to remove people from the list and defend them against sanctions actions, but I'm a big believer in the efficacy of U.S. sanctions when applied appropriately, and I think they can be a great tool. Do we rely on them a little too much? Yeah, probably, in my opinion, we do. But when targeted and when used in a transparent way, they're incredibly effective and really can further U.S. policy interests.
Erich, thanks for a fascinating discussion and for helping us kind of look under the hood of the SDN list.
Anytime. Thanks, Yar. Thanks for having me on.
I'm Esfandir Batmangelic, and this has been The Sanctions Age. Our show is produced by Spiritland Productions. Thanks for listening.